Welcome to our evaluation of judges as policymakers. Courts make law, common law, by deciding cases and establishing legal principles that bind future litigants and judges. The lawmaking function of courts ensures that judges have a powerful role as public policymakers. This is particularly true of judges who serve in appellate courts such as the state Supreme Courts, the Federal Circuit Courts of Appeals, and the U.S. Supreme Court. Because of their policy-making role, judges participate in a larger political discourse that goes far beyond the concerns of individual litigants. As we consider in this section, judges are not free to act completely independently of the other branches of the government, but they are able to weigh in on some of the country's most important issues. Supreme Court Justice Anton Scalia has colorfully described the crucial role that judges play in using the law to create policy. As Scalia sees it, the ideal judge is one who has the intelligence to discern the best rule of law for the case at hand, and then the skill to perform the broken field running through earlier cases that leaves him free to impose that rule, distinguishing one prior case on the left, straight-arming another on the right, high-stepping away from another precedent, about to tackle him from the rear until, bravo, he reaches the goal. Good law. Most recently, the courts have been called upon to resolve issues related to the war on terror, the death penalty, the powers of the chief executive, freedom of speech, abortion, euthanasia, and affirmative action. What does it mean to be a policymaker? If you think back to our chapter on Congress, policymakers are individuals have authority to influence or determine solutions, public policies that addresses the issues and problems a society faces. After choosing a policy, the policymaker must stand ready to adapt to its changed situations or new challenges. When considering the court's role as policymakers, legal analysts often categorize judges and justices as exercising either judicial activism or judicial restraint. Judicial activism refers to the court's practice of applying their authority to bring about particular social goals. Let me repeat that. Refers to the court's practice of applying their authority to bring about particular social goals. It reflects the notion that the role of the courts is to check the power of the federal and state executive and legislative branches when those government entities exceed their authority. During the Warren Court, the tenure of Chief Justice Earl Warren from 1953 to 1969, the Supreme Court took an activist stance, most notably in rejecting the constitutionality of racial segregation. By borrowing Southern states from segregation in a variety of contexts, including schools and other public facilities, the activist Warren Court powerfully bolstered the effects of civil rights activists. The activism of the Warren Court was also instrumental in shaping the modern rights of the accused. During Warren's tenure, the Supreme Court established Miranda rights for individuals accused of a crime and mandated that states provide counsel to each such defendants when they cannot afford an attorney. That is Miranda v. Arizona and Gideon v. Wainwright. The Warren Court's activism also shaped modern definitions of the privacy rights of individuals, which would later form the framework for the court's thinking about abortion rights. Supported by presidents who enforced its rulings, the Warren Court took on a leadership role in changing the nature of U.S. society. Some judges reject the idea that the court's role is to actively check legislative and executive authority, noting that officials in those branches are elected to carry out the people's will. These judges observe judicial restraint, the limiting of their own power as judges. Practitioners of judicial restraint believe that the judiciary, as the least democratic branch of government, should not check the power of the democratically elected executive and legislative branches, unless their actions clearly violate the Constitution. By tradition, judicial activism and judicial restraint are linked, respectively, with the liberal and conservative ideologies. That neat categorization, however, breaks down when one tries to apply it to recent courts. The Rehnquist Court was both conservative and activist. That court chose to hear a case, Planned Parenthood of Southern Eastern Pennsylvania versus Casey, C-A-S-E-Y. Please pause, rewind, and write that down. Planned Parenthood of Southeastern Pennsylvania versus Casey, C-A-S-E-Y, 1992, that checked the authority of the state of Pennsylvania to implement a state law that limits access to abortion. In its decision, the court laid the framework for the tightening of abortion laws in many states by clarifying what measures the states could take in restricting abortions. When judges and lawyers consider a case, the common law tradition, specifically the principle of stare decisis, means that they must consider past cases with similar facts and legal questions. They must be guided by how courts in those cases have interpreted the underlying legal issues. As we have seen, the legal principles that come out of these cases constitute case law. But even though stare decisis binds jurists and attorneys to prior case law, this does not mean that judges, in ruling on new cases, simply apply previous decisions to new circumstances. Rather, in interpreting the legal precedent, they typically choose among several cases related to the legal issues at stake. And their choice often determines the outcome of the present case. For that reason, law school students become skilled at identifying the line of cases that might help them to succeed in making a particular argument. They must assume, however, that the lawyer on the other side of the courtroom will also select cases that best support the attorney's chances for success.